the discussion, I will attempt to answer some of the questions of Professor Jerencinovic, and in the presentation I would like to speak about in detail the methodological choices, why we excluded, for example, the concurring and parallel distinct opinions. In this presentation, I'm going to discuss the study of the research group set up within the framework of the Ferenc Márdulyi Institute and the results thereof. The research allowed us to identify the specificities of the constitutional reasoning of the constitutional adjudication in the Central and Eastern European countries and to compare them with the features of the interpretation of the European Court of Human Rights, or ECTHR, or Strasbourg Court. I just wish to talk briefly about the research design, and I will concentrate mainly on the results of the research. The participants of the research group reviewed the constitutional adjudication of 6 Central and Eastern European countries, as was mentioned before. Before anything else, I would like to thank them here for the amazing work the participants did during the research period, this very short research period. In alphabetical order, Professor Benjamin Flander from Slovenia, Professor Adél Köblös from Hungary, Professor Piotr Mostovic from Poland, who unfortunately cannot be present at this conference in person, Professor Slobodan Orlovic from Serbia, Professor David Zenálek from the Czech Republic, and Professor Katarina Smilova from Slovakia. Special thanks them for that they endured to be asked several times to revert certain passages of the text or to reclassify certain interpretative operations into other methodological categories or to reshape the table of the results. I would like to grab this opportunity to thank all of you for your constructive cooperation, for your immediate replies or almost immediate replies, and that you complied with my request time and again and again. This shows that the heart of the book and the main results of the research was the 6 country studies in which the colleagues, the participating professors, analyzed the Constitutional Court's reasoning in the given countries, as well as the European Court of Human Rights' interpretation methods. These are the results which made the research worthwhile and which I hope will provide novel findings that are not yet known to the profession. Due to the research design, each national researcher had to analyze 30 important decisions of the given constitutional court, in which the Constitutional Court made a decision in the last 10 years on the merits with a substantive reference to either European Court of Human Rights or European Court of Justice decisions. These 30 cases had to be analyzed according to a certain methodology, which can be read on the volume. The aim of this was to identify, on the one hand, the argument types that the constitutional courts prefer in cases with international relevance, and on the other hand, the style of reasoning which characterizes their decisions. It was then necessary to see what methods were used by the referred supranational courts, mainly the European Court of Human Rights. It was hoped that we would be able to establish how and to what extent the style of reasoning of the decisions of the analyzed constitutional courts differs from the style of reasoning of the decisions of the analyzed supranational courts. As for the methodology, we classify the methods of interpretation as follows. We distinguish firstly the par excellence linguistic arguments. This means on the one hand the semantic and on the other hand the syntactic interpretation. The semantic meaning, as for the semantic meaning, it consists of the legal dogmatic meaning, the ordinary meaning, and some other technical meanings, some other professional meanings. Second, the logical arguments, the domestic systemic arguments, for example, contextual interpretation, or references to the previous constitutional court decisions or the previous practice of the constitutional courts, references to the case law of the domestic ordinary courts, and so on. The external systemic and the comparative law arguments, for example, the references to international treaties, the references to the case law of supranational courts, or references to the legislation or case law of other countries as a classic or traditional comparative law arguments. The objective teleological arguments, that is the purpose of the convention or the purpose of the constitution in question. The subjective teleological arguments, which means the intention, the will of the legislator, or in this case, the will of the constitution maker or the drafter of the convention. The jurisprudential arguments, the seventh method. This means the references to scholarly works of specific authors, which was named by these specific authors, commentaries, articles, and so on. Arguments from general legal principles, which covers the whole legal system, for example, the nemo plus iuris, or the ignorance of law excuses no one, and so on. And in the end, the substantive arguments, these are the arguments of a direct moral or economic or scientific nature which stem from outside the law. In the case of the Strasbourg court, we have made some minor changes to the methodology, but this hasn't affected the main findings of the research. As for the aggregated results of the Central and Eastern European countries, this can be shown in this a bit complicated and detailed slide. We can draw some conclusions solely on this basis, the altogether result, but other conclusions require a separation of the results for each country. So, further decisions per country, or 180 in total, were examined by the participating professors. At first glance, it may seem, in line 4b, that the practice of international courts is the most relevant source, as this method was used in 100% of the cases, but this is merely an illusion due to sample bias, since the criterion of the selection of the cases was that these decisions should contain references to international case law. Therefore, these necessarily contained international references. This doesn't mean that this would be a common practice in the constitutional courts. To draw such a conclusion would be the change of the causes and consequences. This simply means that we were curious about this type of decisions and the argumentation contained therein. And the same bias is also the cause of the relatively high number of interpretations which refer to international conventions, also as part of line 4. What is remarkable is that in all the examined countries and all the examined constitutional court practice, the primary method of argumentation was the reference to the previous constitutional court's practice. It occurred in almost 90% of the cases. In this context, it is characteristic of all the examined constitutional courts that they don't simply refer to the previous practice, but they cite in detail the specific constitutional court decisions one by one of the earlier cases. This brings the constitutional courts close to the courts of precedent or courts of case law. This may be due to the fact that constitutional court judges can spare the work of argumentation by reference to previous case decisions and case reasonings. Generally speaking, it seems that the longer a constitutional court has been in operation, the more precedents it will cite. There are several reasons for this. First, constitutional courts tend to cite not just one, but usually several, even a dozen earlier decisions in a case. So there will always be precedent decisions not disputed by the constitutional judges as a compromise. Second, constitutional courts can increase the legitimacy of their decisions by referring to precedent decisions, regardless of whether or not these decisions played a prominent role in the subsequent case. Third, the use of previous decisions is also efficient from the point of view of labor savings. The always busy bodies need to invest less time and energy in the constitutional reasoning, since most of it has already been done by the previous constitutional court decisions. Thus, it is no coincidence that almost all examined constitutional court decisions contain reference to at least one, but typically several previous decisions. The use of this way of reasoning was decisive, or at least defining, in most of the cases. Thus, the constitutional courts of the Central and Eastern European region can be considered as quasi-precedent courts. The second most common type of argument was contextual interpretation. This is due to the requirement that fundamental rights must form a coherent system, so the tension between conflicting fundamental rights at the level of the text must be resolved. Determining which fundamental right has primacy over the others in borderline situations requires the application of different measures and tests, which approach in itself involves a contextual interpretation. Contextual or harmonizing arguments are therefore necessary and unavoidable in a large number of cases in order to respect the principle of the coherence of the Constitution. Before starting the research, I expected that the grammatical, that is, the textual interpretation, would be one of the most influential and one of the most important ones, in addition to the previous practices of the constitutional courts. This assumption was only partly confirmed by the results of the research, while the legal technical, that is the dogmatic meaning, occurred in about 70% of the cases. This was really a frequently used method. The exploration of the everyday meaning of words was not. The reason for the widespread use of dogmatic meaning may obviously be that the text of the Constitution is a normative text, is a legal text, and the meaning of its terms have to be relevant from a legal point of view. The argument from ordinary meaning, however, was used less, perhaps because this meaning is often clear, at least according to the constitutional courts, and therefore its explicit interpretation is simply not necessary, according to the constitutional courts too. Among the external systemic arguments, line 4, the numerical results concerning either the case law of the supranational courts or the international treaties are a bit misleading. In fact, they are invoked in only a small proportion of cases. The only exception is Serbia, where this is an established way of interpreting the constitution, and the case law of the European Court of Human Rights in particular is a point of reference. An important and general result of the research is that it is much more common for the constitutional courts to refer to the practice of the European Court of Human Rights or to the cases of the European Court of Human Rights than to refer to the European Court of Justice. However, it was a bit surprising that Central and Eastern European constitutional courts did employ other international sources as well, with remarkable regularity. Almost all examined constitutional courts refer to them, with the exception of Slovakia, and in very diverse forms. Comparative law arguments were of medium frequency in Central and Eastern Europe, except in Poland and Serbia, where these were not common. However, their role is largely illustrative, and they don't determine the merits of the decisions. They are mainly used by the constitutional court judges in order to be able to prove that their reasoning is not unique, is not specific, and it occurs also in other countries as well. And the decisions of the German Bundesverfassungsgericht were cited relatively most often. The examined constitutional courts applied logical arguments to different degrees. The Czech and the Slovak constitutional courts used them to the greatest extent. The use of objective teleological interpretation, that is, the argumentation on the purpose of the constitution or on the purpose of the constitutional provisions, varied greatly in the analyzed examples. In most countries, it was found in only a few decisions. Only in Serbia did it appear in almost half of the decisions. It is worth noting that even in Hungary, the explicit use of this method is rare, although in principle, according to the textual provisions of the Hungarian constitution, the fundamental law, this should be a mandatory element of the constitutional interpretation. As for the use of subjective teleological arguments, these are not at all common in the analyzed Central and Eastern European countries. There is little reference to the intention of the constitution maker, the justification thereof, the historical social circumstances of the constitution making process, or to the travel preparatoire. One of the most interesting and most controversial issue is the use of references to jurisprudential works. That is when the Constitutional Court refers to monographs, commentaries, notes, articles of specific authors in its interpretations. In some countries, such references hardly appear at all. This is the case, for example, in Hungary or in Serbia. But in others, it is an established tool of interpretation, for example, in Slovenia and Slovakia. Finally, substantive arguments are among the rarely applied methods in the analyzed constitutional courts. These few occurrences are quite diverse. They include references to expert opinions, the equity, public interest, good morals, common sense, and so on. Although the hypothesis of the research was that a constitutional court dealing with human rights at the borderline of law and morality would more often resort to moral considerations or other non-legal arguments, The results of the research show that this is not the case. Substantive references are the exception rather than the rule. The reason for this is certainly that although human rights are indeed rights of moral origin, they are still part of the positive law. Thus, interpretation and application of constitutional fundamental rights as part of positive law is sufficient to be guaranteed that the outcome of the given constitutional matter will be not only legal but also moral and just. As to the European Court of Human Rights, by far the most important, most frequently used and most influential method of interpretation is the court's own previous practice. In all the court decisions, there were references to previous jurisprudence. The Strasbourg court is a hybrid court, essentially close to a court of precedent, and the employed arguments evidently corroborate it. In the past, it was typical that the later a decision was made, that is, the closer we were today, the more precedents would be cited by the ECTHR. Now the policy has changed, and the requirement now is that only the last relevant decision have to be cited by the court. By this, the court can avoid the endless citation of earlier decisions, but of course it may raise problems, as in most cases it is not the last decision that informs us of the principles and values on which the decision was based. This evidently raises legal certainty issues. In addition to the previous practice, contextual interpretation was used in a significant part of the cases, as it appeared in vast majority of the decisions. The credo of the Strasbourg court is that single provisions of the convention cannot be interpreted in isolation, but only with respect to each other. This is the requirement of the so-called harmonious interpretation. And another frequently used method is the grammatical interpretation, within which the legal technical meaning, the dogmatic interpretation, predominates. Legal meaning always covers the legal sense of the Strasbourg court's own convictions. Hence, the court doesn't use the legal concepts of the contracting states, but the conceptual meaning on the basis of the dogmatics created by itself. This is the so-called autonomous interpretation. And teleological interpretation is also a frequently used method. Such a reference occurs in about half of the cases. The exact proportion cannot be determined because the interpretation on the basis of the purpose is typically in conjunction with some other methods as a kind of collateral finding. As the Vienna Convention on the Law of Treaties expressly mentions this method, and as from 1975 the Strasbourg court has considered that the rules of the interpretation of the Vienna Convention are also binding on the court in the course of interpretation of the European Convention, it is understandable that this method is more frequently used by the Strasbourg court than by the national constitutional courts. As for the similarities, the most important similarity in the practices of the Central and Eastern European constitutional courts and the European Court of Human Rights is the very similar standard for restriction of fundamental rights. Although each forum uses specific standards for certain human rights, for example, the right to a fair trial, they all use the proportionality test, the so-called proportionality test for limitation in case of a conflict of fundamental rights. The domestic constitutional courts and the European Court of Human Rights also share the used key concepts. Each of them attaches great importance to the principle of rule of law, to the principle of democracy, both of which are enshrined both in the national constitutions and the European Convention. Finally, as already mentioned, it is also a common feature that all pay particular attention to their own previous practices. Of course, these were just a few highlights that fit into a 25-minute presentation. Besides these, each national chapter produced many very interesting and novel results thanks to the thorough and excellent research work of the participating professors. I hope that you will all find the results of the research interesting and the book useful. Thank you for your attention.